Well, this is the Bills Committee on Bankruptcy Amendment Bill 2015. Item 1 on the agenda. To elect the chairman for the Bills Committee. Will members please nominate a candidate for the chairmanship? A valid nomination should be made orally by a member and also to be seconded by another member orally and also be accepted by the committee. Yes, Mr. Christopher Zhang. Yes, Mr. Chen Kam Lam. Mr. Ng Long Sing seconds. Mr. Chen Kam Lam is not here. Is he in room 3? Is coming over, is that right? Should we wait a bit and see if he accepts? Somebody nominates you, and will you accept the nomination? Do you accept? Somebody has nominated and another member seconds. So Mr. Chen Kam Lam agrees. Would Mr. Chen Kam Lam please come up? Oh, any other nomination? If not, then Mr. Chen Kam Lam is returned uncontested.
半尾啊，都未爭好多人啊，爭好多人。係啊，使唔使？有冇得休會5分鐘咁過去嗰邊？
There isn't a quorum in the other room. Shall we adjourn here for 5 minutes? We only need 3.
係嘛？哦，我聽聽大家同事嘅意。
Well, let's hear from the members, shall we? It seems there isn't a quorum in the other room, so if we're required to go there to form a quorum, we may have to adjourn this meeting for a couple of minutes. Otherwise, we can carry on. So may I welcome from the FSTB the Principal Assistant Secretary, Mr. Paul Wong, and the Official Receiver, Ms. Teresa Wong. And the Senior Government Counsel from the Department of Justice, Mr. Alan Chong, and Assistant Official Receiver, Ms. Fiona Lee. Welcome to the meeting. So, members, you should have with you the relevant papers. Perhaps I'll invite the government to walk us through the paper first, and then we can move on to handle other issues. PAS. Members, Chairman, good morning. This meeting is about Bankruptcy Amendment Bill 2015. One of the objectives is that in relation to a Court of Final Appeal judgment handed down earlier on the existing bankruptcy ordinance, it was ruled that one of the provisions is unconstitutional and that there is excessive constraint on the rights of the bankrupt, and we're therefore proposing an amendment. About the existing bankruptcy ordinance, pursuant to the LRC's recommendation, there is an automatic discharge mechanism. That is, a bankrupt will automatically be discharged from bankruptcy on the expiry of the relevant period, which runs for 4 years for first-time bankrupts or 5 years for repeat bankrupts, and so as to give another chance to the bankrupt as soon as possible. And according to the LRC's commission, the automatic discharge from bankruptcy could be suspended if the bankrupt is not cooperative with the official receiver. And that is, there is an objection regime. A trustee in bankruptcy of a creditor may apply to the court to object to the automatic discharge of the bankrupt. And if the court accepts the reasons proposed by the trustee in bankruptcy or a creditor, the 4-year period of bankruptcy would be suspended for up to 8 years. That means the total period of bankruptcy may span from 4 to 8 years at most. The other mechanism is the abscondee regime. This is the crux of this bill. That is to say, if the bankrupt leaves Hong Kong during the running of the relevant period, the running of the relevant period will be suspended automatically until the bankrupt has returned to Hong Kong and notified the trustee in bankruptcy of his or her return. And earlier, the Court of Final Appeal handed down a judgment and ruled that one of the provisions of the abscondee regime unconstitutional on grounds that the provision on the bankrupt's right to went beyond what was necessary for the protection of the rights of the creditors. For the 3 reasons: A, the sanction operated irrespective of the reason for the bankrupt's failure to fulfill his obligation, and B, the sanction applied indiscriminately to all situations, and C, there was no discretion vested in the court. So as long as the bankrupt has left Hong Kong without notifying the TIB, then automatically the running of the relevant period will be suspended, and there is no discretion vested in the court. And against this background, we reviewed the regime and reported to the panel on financial affairs on the review outcome in May 2014. And the panel was inclined to introduce new arrangements to replace the existing abscondee regime by way of an interview arrangement. And the stakeholders have been consulted who support this bill. So we propose to introduce new arrangements to replace existing abscondee regimes so as to address the constitutionality issues of that regime. And under the new proposal, the court will be given discretion. Say if the TIB or the representative of the creditor can hold an initial interview with the bankrupt during which reasonable questions may be raised, and if the bankrupt fails to attend the initial interview, or if the bankrupt is unable to provide the necessary information during the initial interview, the TIB may apply to the court to ask for a non-commencement order of the relevant period. That is, the commencement of the relevant period will be suspended until the conditions imposed by the court have been met. And then the TIB will have to notify the court, and the relevant running of the relevant period will commence. And this will give the court the discretion to consider the reasons why the bankrupt is unable to provide information or fails to attend the initial interview. And the TIB will need to state the impact on the administration of estate by the TIB in its application. And perhaps when we come to the scrutiny of the bill, we can go through the measures which provide fairness to both parties. Well, as explained just now, if the bankrupt fails to complete an initial interview prejudicing the estate administration by the TIB, an application can be made with the court for making an order to treat the relevant period for the bankrupt as not commencing to run. And the court may also specify in the non-commencement order the terms that will trigger commencement of the relevant period. And if this is done, the bankrupt's automatic discharge from bankruptcy will be deferred, and that the TIB must file a notice with the court within 14 days if the bankrupt then complies with the terms specified by the court, and the relevant period for the bankrupt will commence to run on the date of compliance. So much for my presentation. I will invite the members to declare their interest. First, if you have ever been involved in any bankruptcy matter or in the administration of estates, if there are indirect or direct pecuniary interests, please declare your interest accordingly. Any member? No? So questions from members, please. Mr. Tan Ka Pio. Sorry, I am not very familiar with the law. I have a number of questions. Now, I hear the key is that whether the petition is made by the bankrupt himself or by the creditor. If a bankrupt fails to complete an initial interview, then a non-commencement order will be issued. That is to say, the automatic, the relevant period will be extended automatically. Now, what if the bankrupt attends an initial interview and then a year on, the bankrupt suffers so much financial hardship that he decides to live on the mainland and rely on relatives? What about subsequent interviews when forms will have to be filled? If he fails to notify the official receiver or the TIB, what will happen? I want to clarify that this bankrupt has attended and completed the initial interview. Mr. Wong, Ms. Wong. Well, if he has completed an initial interview, then he can go to the mainland to work or otherwise, as long as he tells the TIB his contact address and means of contact and phone number. So his liberty will not be affected as long as he completes an initial interview. He may immediately tell the TIB that he will be living in Guangzhou, relying on a relative. As long as he make the notification, he won't be prevented from doing so. And this will also count towards the 4-year bankruptcy period. So that means regardless of whether he has or hasn't any income, he will have to make an annual return, yes, whether or not he has income or not. Let me supplement. The policy objective is that the bankrupt is obliged to assist the TIB to realize his estate for repayment to his creditors. So after completing the initial interview, the bankrupt may choose to leave Hong Kong and live somewhere else. But the important thing is for the TIB to be able to contact the bankrupt, say to attend an interview or to sign papers to realize his assets. A follow-up question. What if the bankrupt leaves Hong Kong and he has provided the means of contact and subsequently the TIB is unable to contact the bankrupt? So how will this be dealt with? Of course, we'll try other means to contact the bankrupt. But if he still cannot be located, then he may be considered non-cooperative, and we may apply for extension of his bankruptcy period to up to 8 years. So that's under the existing regime. Dr. Kenneth Leung, I want to ask about the PowerPoint, about new arrangements. The court had the discretion to suspend or commence the automatic discharge of bankruptcy, and that there is a greater degree of discretion by the court. But one point addressed in, these are the 2 points addressed in the bill. 版嗰度咧，
有個背景嗰度咧 ，B 嗰度咧個 abscondee regime 其實你而家喺呢一條標嗰度係做咗啲咩改變啊？嗱，你呢度 B 嗰度你就寫住個 abscondee regime 咧就係 running of the relevant period for a bankrupt who has left Hong Kong under specified circumstances will be suspended automatically。咁呢個係現有嘅個 arrangement 嚟噶嘛？咁你而家喺呢個標度由於個 Court of Final Appeal 嗰個judgment， 你其實
Due to the judgment by the Court of Final Appeal, what changes have you made? You are talking about the suspension of the running of the relevant period instead of the commencement of the relevant period. Can you elaborate to members? Because some of us might not be very familiar. At the moment, what kind of travel arrangements must a bankrupt make if he or she plans to travel, and what changes will be incurred with regards to the bankrupt's travel arrangements? We are looking at two questions. The first question is on the changes made to the abscondee regime made by the bill in response to the judgment by the Court of Final Appeal, and the second question is the travel arrangements for bankrupts under the bill. Perhaps I will address the first question first. If the bill is passed, the entire abscondee regime will be repealed, and all the relevant provisions would be cancelled, and there will not be any provisions for the suspension of this the relevant period. If the bankrupt fails to fulfill his responsibilities, the relevant period might be suspended until the bankrupt has fulfilled his duties again. And the Court of Final Appeal cited three reasons, and the existing abscondee regime is unconstitutional. And under the new system, the trustee in bankruptcy must make an application to the courts, and as such, the bankrupts can explain the reason for failing to attend the interview. It might be due to unreasonable time slots drawn up by the TIB, and or the bankrupt may have some special reasons for not submitting the relevant information. And the court will see whether the TIB has valid grounds for making such applications. And under the existing abscondee regime, it's applied across the board, and it does not take into consideration the different stages of bankruptcy. And as such, the initial stage of bankruptcy is very important. If the bankrupt fails to attend the initial interview, the trustee in bankruptcy can not get hold of any information and facilitate estate administration. And as such, the trustee in bankruptcy might be prejudiced. And as such, the court might grant a non-commencement order. And under the existing provisions, under the abscondee regime, if the bankrupt does not notify the TIB of his departure from Hong Kong, the non-commencement order will be enforced. And since this is a very important decision, the court should have some sort of discretion. And under the new proposal, the court will hear both sides of the story and decide whether any prejudice is effected. And even if the TIB gives valid grounds, the court might not necessarily agree to granting the non-commencement order. this is a question on the existing regime, right? Right now, bankrupts can travel. It's not an issue as long as he or she provides their contact method and address. When would the non-commencement order be triggered under this regime? In the automatic suspension of the relevant period, once the period is enforced, it won't be suspended, right, under the current regime. Before the order was issued by the Court of Final Appeal, the relevant period would be stopped, but this arrangement was ruled unconstitutional by the CFA, and as such we cannot effect it anymore. I have a question on the actual operation of the arrangement. Of course, abscondees won't notify you of their departure. So when would the relevant period be suspended? Because you have no idea when the abscondee has left. And by the time you realize the abscondee is gone, you might not have enough evidence. So what is the scope of your power, and how would you decide when the relevant period is suspended? The abscondee would, the bankrupts would reach out to either the TIB or the official receiver's office. By abscondee, you would have no idea when he leaves Hong Kong. The official receiver's office will reach the will get hold of the immigration department to check the records. Without the help of the immigration department, you have no way to know when the abscondee has left Hong Kong, right? You would estimate when he or she would return, and this period would still be effective. The relevant period will be suspended until the abscondee returns and notifies us of their return. I think what the official receiver meant was that the official receiver's office would work with the immigration department to see when the abscondee departs Hong Kong. If the abscondee departs Hong Kong legally, there would be records under the immigration department. And what Mr. Ng Leung Sing said was that if the abscondee is uncooperative but remains in Hong Kong, it cannot be tackled under the existing regime. But under the new regime, the bankrupts must attend and complete the initial interview. So the focus is on facilitating estate administration by the TAB. So whether the bankrupt is in Hong Kong or not is not as important anymore. The idea is to help the TIB facilitate estate administration, and this is more important than the fact whether the bankrupt is in Hong Kong or not. Any other questions? I'd like to seek members' views on whether we need to hold an open hearing to take in views from the relevant stakeholders and the trade. Do you think we have a need to do so? Mr. Ng Leung Sing. Since 2002, there have been a lot of questions on the existing mechanism and whether it's biased towards bankrupts. We can think about whether or not to invite the business sector or district councils, but I do think we should give the business sector a chance to speak out and voice out their view. because they would inevitably be affected. So we can meet some chambers and trade associations. And hopefully we can invite the Hong Kong Association of Banks and the DTC Association. And hopefully we can take in their views. I think other professional bodies will be interested as well. Because other professionals might be trustees in bankruptcy. And on the list we have the Hong Kong Law Society, the Hong Kong Bar Association, and so on. They should be invited to give their views. We will notify the relevant bodies, and we'll have an open hearing for district councils as well. We would not invite members of the public. The bill amendment is rather specific. It's not an amendment across the board. Do members have other comments on this bill? Since we have to take in members from the public as well, we cannot enter the clause-by-clause examination just yet. If we don't, otherwise it will be rendered irrelevant. If we have no other questions, the meeting is adjourned. I will work with the Secretary to see if we have available time slots coming up. And we need to reserve some time for to take in comments from the public. Under the bill, these new provisions will be enforced in November 2016, and by October or November this year, when the meeting resumes, this bill would hopefully be passed by the end of this year. If the official receiver's office and other departments, they would need some time for preparation. And under the existing abscondee regime, certain legal provisions will still be enforced for some time. So I work with the Secretary to find a right time slot. We have a lot of meetings coming up, and before the recess in July, we might not be able to finish the scrutiny for this bill. We need 10 days to 2 weeks, and we will invite the public to give their views. And after mid-June, we will have another meeting or two to deal with comments from the public and deal with the clause-by-clause examination. And there might be amendments by that time, and we might need more time than expected, and we might not be able to wrap up everything before the summer recess. And after that, hopefully we can resume the meeting as soon as possible. So that's the plan. If we have no other views, the meeting is adjourned.